So is this motion from 2020?
Yeah, he's been in custody since then.
Oh, gotcha. Good morning, sir. Eugenius Pugh.
Yes, ma'am.
And will your client waive the formal reading of the motion?
He will, Your Honor.
My computer's going slow. All right, Mr. Pugh, in cause number 15-21944, I have a motion to revoke your unadjudicated probation. And will he waive the formal reading of that motion?
He will, Your Honor.
It shows that you were placed on probation June 22nd of 2015 for the offense of retaliation, and that was a 5-year deferred probation that's been extended. Is that correct?
Yes, ma'am.
It alleges in count 1 that you committed the new offense of robbery, threats, November 27th of 2020 in Harris County, Texas, and is that true or not true? Count 2 alleges that you committed the offense of assault family violence on November 27th of 2020 in Harris County, Texas, and is that true or not true? And then finally, count 3 alleges that you committed the offense of robbery December 5th of 2020 in Harris County, Texas, and is that true or not true? Did you enter, and the state abandons 4, 5, and 6, correct?
That's correct.
Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because you actually did what they say? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Pugh's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence at this time to find you guilty and find you guilty of the 3rd-degree felony offense of retaliation. Sentence you in accordance with your agreement for a term of 3 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I am handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Ms. Holmes. All right, good luck to you, sir. You can go back with the bailiff.
Thank you.
Yes, ma'am. Good morning, sir. Are you Preston Fontanet?
Yes, ma'am.
And Mr. Fontanet is charged with unlawful possession of a firearm by a felon. And looks like in March, failed a drug test in court, tested positive for cocaine in court, and so I revoked his bond.
He then pled guilty, Your Honor, and the plea was not accepted based on statements he made in his PSI. We had that sentencing hearing a few weeks ago.
Okay. Mr. LeBlanc has filed a motion asking that I set bond, and I made made the finding that it was appropriate at that time to have no bond. Is that correct, I guess? There's no bond set at all? Hold on. You wrote it on the sticky, but I just don't know why. I'm trying to go back and see why I would.
I think, I believe that he was in the bond. I think I even went back and looked in my docket, and that's what you said.
Okay. I'm sure I had a reason. All right, so Mr. Fontanet, do you intend to ask your client any questions?
Judge, if I may, could we set this aside and possibly, we'd like to readdress the offer and accepting this state's offer, and my client would like to address the court if possible. That's really where we're headed if it's the court will permit.
Well, here's what I would like to do, because I've obviously slept since then and don't recall everything. However, I do remember some things. I am going to want some time to go back and see exactly what happened in court that day for me to do what I did.
It's a one line, Your Honor. His version of events was, I quote, "I didn't really commit a crime at all. I didn't do anything."
Right. I just wonder if there was something else said or done as to why I did a no bond. There was.
I don't have a note on that, Judge, so I can't answer that.
Just handed me this, I'm sorry.
I don't know the judge.
I don't know if that helps.
I still think that. Well, I mean, it's been rejected, so there's no going back, and y'all would have to redo paperwork and all of that kind of stuff. But before we do that, I really do want to go back and see at the last court hearing or two, and I'm not going to be able to do that obviously this morning, so I can reset it just 1 week to next week. And between now and then, I'll get Ms. Tanner to pull up so that I can go through, figure out exactly what happened while we were here on the record, and then I will let y'all know if I feel like I would I mean, there was also the fact that he just got revoked on 2 different cases
That's true, Your Honor. He does have 2 revocations on his other felonies.
and got 1 probation while he was on probation for the other and then messed that up. So I'm not real sure that
Right from the start, the judge isn't wasting any time. This motion to revoke probation could send him straight to prison. And look how calm he seems.
that's part of what my notes are here anyway. So let me reset it for a week. Let me get caught up on what I can't remember on why I no bonded it. I'm sure I made some finding on that so that I can see where I was, and then let's not talk about the bond today until we know what we're going to do on that. I'll reset it for 1 week.
Thank you.
So we'll be back
Now,
next
if
Tuesday.
the court would like to do it sooner, I'll be available.
Yeah, I don't think we can do it this week, but we'll take care of it next Tuesday. Ms. Capel in cause number 24 DCCR 1037 and 2240550 is on probation, and there's MTRPs filed. What is the announcement?
Just going to enter pleas of true, Your Honor. There's no agreement, and we were going to ask, I have a question I was going to put to the court about the restitution of the case.
Okay, what is
You have
that?
a PSI come back in November, because it says previously a bond forfeiture, she must have pled and then had a bond forfeiture.
I've got a copy of the PSI in my file as well, Judge.
So, okay, well, let's go back then. It looks like Ms. Capel was in court sometime back in November of 24 or October of 24. The case was set for sentencing January of 25, and there was a bond forfeiture. Ms. Capel didn't show up for that sentencing. So I guess the question is, are y'all ready to go forward on sentencing based on this pre-sentence report?
The state's ready to proceed.
Your Honor, if I may, I believe in consulting with the probation officer, there's $2,446 in outstanding restitution. I'm sorry, 26.
2,426.
26, not 26. The defendant is, could possibly, with
Are you making,
with difficulty
hold on,
could come up with that rest-
hold on.
Okay.
Are you making an argument on what you want me to do right now?
Well, she hasn't paid the restitution up front yet. My question to the court is to be direct, as if she were to do that, would that affect the court's sentencing decision if upfront restitution was paid in full? Because I don't want to tell, pay the restitution in full and it doesn't have any impact, because Mr.
But we're
Coleman,
here for sentencing today, so I feel like it's too late for that.
Well, she could, if I could reset it to Monday, if we could possibly pay it
I
this
think
week, if
there's
that's
still,
gonna
well,
impact.
we still have to talk about failure to report, failure to
Right.
submit to alcohol drug testing, failure to comply with JCDI and her drug patch, and the fact that she didn't show up for her sentencing, and so.
Correct, Your Honor. I understand all of that. She's already pled true, I'm sure, to all of that. But would it affect the court's sentencing decision if the restitution were paid, is my question.
I
Because
would,
with Mr.
I would
Coleman,
think
it doesn't
common
care.
sense would tell you that anything you can do that you're supposed to
Okay.
do while you're on probation would probably help. I don't know that that's going to help you stay on probation, but help in some way potentially. Yeah, I mean,
Okay. Can we reset it for Monday for sentencing then, to they don't get paid this week,
that'll be Tuesday.
or Tuesday? Then we can proceed with sentencing Tuesday.
Yeah, and I'm going to want information on where she's been, what she's been doing since she didn't show up and when we got her in custody. I don't know if you can visit with her here and just kind of do a little update for me. That would be great. All right, we'll reset it for 1 week. I need to look at this one too, because I guess because she didn't show up, I don't have any notes on it. It's almost like I didn't.
Because it wasn't set for sentencing. I never just set this for sentencing, because I don't know if you're gonna
Okay.
accept it or not.
Gotcha. I'm loading up next Tuesday, aren't I?
Yes, that's okay. Bruce Smith, I think, is all we have, and then I have one other thing that Ashley just told me to add on, but I need to talk to you.
Mr. Smith on Calvin Randall.
Oh, I know. Well,
Calvin Randall, Mr. Smith, and Mr. Philip Smith as well. So you're asking,
What is asking if the court will reduce the bond? What's really going on, Judge, is that you got a hearing on a motion to revoke in July the 2nd. He's asking the court to reduce the bond so that he could possibly spend some time with his family before July 2nd in the event you do revoke his probation.
all right, you're Calvin Randall. And so Mr. Randall has 3 new cases. Cause number 24 DCCR 1278, charged with aggravated assault with a deadly weapon. Cause number 24 DCCR 1529, charged with carrying a weapon on alcohol premises. And cause number 24 DCCR 1530, charged with evading arrest or detention with the use of a vehicle. Then we have cause number 21-36882. Mr. Randall is on probation currently for aggravated assault causing serious bodily injury.
That's a full admission. Pleading true means he's admitting he violated probation terms. Basically, game over. The only question now, how long will the sentence be?
There is a motion to revoke probation in that case. There was a request previously for me to set a bond, which I did back in June of 2024. There was a bond set in that motion to revoke case, it looks like, that obviously hasn't been made. There are bonds in all of the others, a $15,000 bond, a $100,000 bond, and a $200,000 bond. And we have gone through, if I'm correct now, what y'all are saying, there were pleas on the motion to revoke, and that is set for a hearing July 2nd.
He pled true to some of the administrative counts.
But we're set for an actual hearing with regard
Approval of the
to,
new offenses, Judge.
okay. And you're asking me to reduce the bond on those cases?
Yeah, he's got a total of like $325,000 worth of bonds on the biggest bond is the motion to revoke bond, which is a $200,000 bond. He's requesting that, I mean, he lives here locally, he's willing to wear any kind of GPS device, whatever. His main motivation is that he would like to spend some time with his family prior to coming back to court on July the 2nd in the event the court does revoke his probation.
Mr. Philip Smith?
State's obviously opposed, Judge. There are some jail incident reports from May 5th. There are also others that go back to
February.
and then some from June of last year as well.
Well, the incidents on May the 5th was deal with, they requested that his blood sugar was above 300, and they requested that he do insulin, and he said, no, I'd like to try to get it down myself. Well, they made that to be an incident.
I'm not worried
Well,
about
it was
that.
also disrespectful and encouraging our inmates to be disrespectful. We want to jail.
Yeah, there's another incident from that same
Two
day.
from that same day.
Hold on just a second. I'm taking judicial notice of the court's file in each of the cases, just to get myself kind of caught up to speed again, reviewing the probable cause affidavit that has to do with those new cases. Okay.
Two of the cases, the misdemeanors were refused by I believe, unless I'm misspeaking.
I don't know what misdemeanors you're talking about. I mean, we've got an evading arrest with a vehicle, we've got unlawful carrying a weapon on alcohol premises, and a new aggravated assault with a deadly weapon, all new cases that have been indicted.
Yeah,
It looks like there was probably, based on the probable cause, I'm guessing there was an evading on foot, potentially, just a regular evading, because that's what one of the allegations.
For example, the weapon on the alcohol is not going to be, as a matter of law, it's not going to be viable because the premises that he was alleged to have been on does not serve alcohol. And the statute's been amended that for him to be guilty of that offense, it has to be a premise in which they serve alcohol, and those premises do not. And
The S&S Grocery doesn't sell alcohol? The S&S Grocery on Concord doesn't sell alcohol?
It sells alcohol, it does not, you cannot consume alcohol. And the statute's been amended to say you have to, it has to be a premise where they consume alcohol.
Okay, I haven't read that, but that's fine. We still have the aggravated assault with a deadly weapon and the evading arrest with a
Correct.
vehicle,
That is-
regardless. Okay, and we're set July 2nd.
That is correct.
No, your motion's denied in all of the cases, I think, based on the nature of the underlying offense that Mr. Randall is on probation for, and the fact that the allegation is a similar allegation, another aggravated assault with a deadly weapon, the evading, all of those underlying facts. I'm going to deny the motion to reduce bond in all of those cases. And we'll see y'all back on July 2nd for that hearing.
And here comes the next case, another defendant, another firearm charge, but this one's messy. He even failed a drug test right inside the courtroom.
Good morning. Are you Nakia Latrell Jackson?
Yes, ma'am.
And Ms. Jackson, in cause number 19-32344, you were here before. You're on a 10-year deferred probation for burglary of a habitation. And there was a motion to revoke your probation filed. You came to court, pled true to counts 1 through 9 in that motion. And I've received an updated pre-sentence report. Has everyone had an opportunity to review that report?
We have it.
Yes, Your Honor, yeah.
Are there any additions or corrections to the report?
Not from the defense.
No, Your Honor.
All right, Mr. Rojas, and there was no agreement, correct?
That is correct. Yes.
All right,
I think we did not reach an agreement.
Right.
okay.
Yeah, Judge, we went over the PSI at the jail, and I discussed her the possibility with Ms. Jackson about the possibility that the previous recommendation had she would have been, at one point, would have been safe P. She tells me that she doesn't feel that she needs safe P. She thinks that all the tools she needs, she got from ISF when she was at ISF. Her problem, she thinks, is that when she was released from ISF, she was homeless, didn't have any place to go. And that one thing led to another. She didn't have a home, didn't have a phone, didn't have transportation. And that's one of the reasons, that she couldn't get into the drop program, which was one of the reasons we're here today. If you read her comments in the PSI, she's asking for another chance, and she truly wants another chance. She tells me that if she's given another chance, she does have a job for her on the outside. She's waiting. She has a job waiting for her at Waffle House. She has two possibilities of where she could be living. She could either go with her aunt who lives in Orange, I believe, who's a school teacher in Orange, or the manager, her manager at Waffle House would let her live with them in Port Arthur. And that's what she's asking me to do, Judge. I know that it's hard because because of the comments on the PSI where she didn't report, didn't go to the drop program, just kind of disappeared for a while. But she's asking me for another chance, and I think she has some comments to make whenever the court feels it's appropriate.
What's the status of the theft case and the failure to ID?
Those are pending misdemeanors, Your Honor.
Okay,
I'll probably dismiss them depending on what
okay. Mr. Nichols?
Judge, I want to make the court aware of the full history on this case. Ms. Jackson was originally on probation before this court on a 2012 burglary. She then committed this offense, and we had a hearing. I think it was a 7-year cap originally, and she was continued on probation. Since that time, she's been ordered to and successfully completed ISF, but then continued to violate probation and was ordered. Would have been sent to safety last year, but then she absconded and stopped reporting. Along with that, I don't think she's done anything really since September of 24, and that's all the violations that are alleged for this motion. So,
Imagine being in
Thank you,
front of
Mr.
a
Nichols.
judge who can't recall your case, but knows she had a reason to
Ms.
deny your
Jackson,
bond.
do you wanna
This
say something?
is where legal memory meets courtroom reality.
she has been given every opportunity, every service that we offer to try to help her, and she keeps coming back to using and not participating in probation. So I think revocation is an order, Judge.
Thank you, Mr. Nichols. All right. Ms. Jackson, do you want to say something?
Yes, ma'am. Thank you for letting me appear and be able to speak on my own behalf today. Judge, whenever I did appear before you last time, I was on 2 10-year probations. I did complete one of them. And since then, I have been to ISF. I learned a lot from ISF. When I was released from ISF, I didn't have a stable place to live. I didn't have anything. And like he did say, I was off my meds. I wasn't in any kind of predicament to take care of myself. Since then, God has blessed me to be reconnected back with my family. I have a stable family support group now, and I can stay back on my meds. If you would give me another chance, I even said I tried the JCDI program or something, maybe out to become a productive member of society. If you allow me to just try, maybe I'll double my fees on probation, do all my classes, try to get off early. I would like to try to get off early, go back to school, be a productive role model for my grandbabies. I learned so much in ISF. I didn't get a chance to fully if you just give me a chance to prove it to you.
I feel like I've heard that before.
I never took ISF.
Hang on.
I'm sorry.
You've been on probation since 2012.
Yes, ma'am.
You didn't successfully complete a probation. We just let you get off of that one because you got on another one. Because while you were on a probation for a burglary of a habitation, you got another burglary of a habitation. And you were lucky at that point because you got another chance. And so here's the thing. You say you've learned from ISF.
I really did.
But, and maybe you did, but if you're going to stay on, the fact that I'm even considering this, so you don't think you need to go to SafeP?
No, ma'am, if you just please, I have a job.
You're not getting out today. You're going to prison or you're going to SafeP. It's that simple. You're not going to keep doing things that you're not, hang on.
Okay, yes.
You're not going to keep messing up.
This is the heart of the courtroom: compassion versus accountability. The judge is torn. Does she give another chance or protect the system from repeat behavior? And there it is, one last lifeline: zero tolerance, one slip, and she's back behind bars. What do you think, viewers? Did the judge make the right call?